Good morning, everyone. This is Dana Parsons, Vice President and Legislative Counsel with Leading Age Virginia. I'm sorry that we've been having some technical difficulties today, but thank you for your patience. If everyone could mute their lines, please. Thank you. Next slide. Okay, everyone, thank you so much. We are going to be going over a brief update on an issue that we've been dealing with at the General Assembly before we get into our discussion about the CMS. And you can CMS, just a moment. Okay, sorry about that. Again, we are going to be going over, before we get into the CMS rule and Osha rule, a brief update about a legislative issue that we are dealing with here in Virginia. Our Joint Commission on Healthcare, which is a commission that works with the General Assembly, has been dealing with a study on the workforce challenges that are happening in Virginia. So we're going to discuss that first, then we'll get into the CMS rule overview and the OSHA emergency temporary standard. So joining us today is Jody Agor, with Director of Nursing of Home Quality and Policy with Leading Age, and Corey Calheim, Vice President of Legal Affairs and Social Accountability with Leading Age. But first, we're going to discuss this issue that's come up with the Joint Commission. The Joint Commission is an established legislative branch within our state government, and it works with our General Assembly to study issues and make recommendations on healthcare provisions and regulations that Virginia should consider. The Joint Commission on Healthcare recently conducted a study called the Workforce Challenges in Virginia's Nursing Homes. The study was recently released and reported to the Governor and the General Assembly. This particular study has been reviewed by a small group of the Joint Commission called the Nursing Home Facility Work Group. They have been focusing on a number of different policy options that are included in the study, but I wanted to bring your attention to two specific policy options that are included. The first one is for the General Assembly for the next session that begins in January of 2022 to have legislation introduced that would require a nursing home staffing standard of at least 3.25 hours per resident day of total direct patient care, total RN, LPN, and CNA hours, including at least 0.4 hours per resident day of RN care, registered nurse care. Option 3 of their study is the introduction of legislation to require nursing homes to provide at least the number of expected total direct care hours and total RN hours that are calculated by CMS based on resident acuity in each nursing home. So Leading Age Virginia, we've been working with the commission members on these policy options for some time now. So after discussion, extensive discussion with the Leading Age Virginia Board, Public Policy Committee, and Workforce Advisory Council, we believe it is the right thing to do for Virginia, for Leading Age Virginia, to support option 3. So we have expressed to the Nursing Facility Work Group that we support option 3, which is basically a calculation that is already in place that nursing homes that are certified are having to meet as part of their 5-star analysis. So basically, if the commission agrees to move forward with option 3, we would see legislation introduced in our next session to essentially require nursing homes to meet this acuity-based calculation that you're already having to meet. This particular study that the Joint Commission completed found that 21% of Virginia's nursing homes are not currently meeting this standard. None of the nursing homes that were comprised the 21%, which were 60 nursing homes in Virginia were leading age Virginia members. But this particular concern that they're not meeting these expected hours is of great concern and a quality issue. So we really feel like moving in the direction of making this a requirement for Virginia could really help these 21% who are not meeting this acuity-based calculation. So our next steps is the Joint Commission, the entire commission will be meeting on December 7th, and they will bring these two policy options, option 2 and 3, to the full commission. Based on yesterday's meeting, the nursing facility work group was leaning towards supporting option 3, but planned to bring before the full group that there were some members of the facility work group that were supporting option 2 for an overall staffing ratio. So at this point, we are still in the preliminary stage. We will be at the table on December 7th and involved in these continued discussions, and we'll keep you all up to date. So please reach out to me if you have any questions. If we have time at the end of the presentation today, I can also address those questions, but we'll be sending you updates and keeping you informed about that. So thank you. I know that wasn't part of today's plan, so I appreciate the opportunity to talk with you about that. So I'm going to hand it over to Jody now for a CMS rule overview. So over to you, Jody.
Thank you, Dana, and hello. Oh, I just realized you're actually listed as Paula. So thank you. Good. Hello, everybody. So the CMS rule has come out, as you all are aware, and so we'll talk a little bit about that. You can go ahead and advance the slide, please. Can we advance the slide, please? Thank you. So the rule was published on November 5th, and it's effective immediately. So there's a 60-day comment period, but the rule in leading age will be submitting comments, but the rule goes into effect now, and there are 2 phases of compliance. So phase 1 compliance is December 5th of 2021, and phase 2 compliance is on January 4th of 2022. So it's a 30-day compliance window and a 60-day compliance window. Next slide, please. And so here is what's required. The phase 1 compliance by December 5th, all staff in your organization need to have either the single dose of the Johnson & Johnson vaccine or their first dose of one of the multi-dose vaccine series, or they need to have submitted an exemption request. And there's a number of policies and procedures that you, as the organization, need to have put in place. And so the part about the exemption request, I want to make sure we don't just like skip over that quickly, because that's something that kind of gets lost, I think. Anyone who is in your organization at December 5th, they have to have that exemption request in. They cannot wait and submit that request by January 4th. It's got to be in the first phase. Of course, anyone who begins in the organization during phase 2 after December 5th, then they would have to submit the exemption request according to your organizational policies and have that in by the phase 2 deadline, January 4th. But anyone who's in there before December 5th needs to request an exemption before December 5th. The policies and procedures that you're going to have, there's quite a lot of them. So you'll need to have a policy to talk about how you're going to get all of your staff fully vaccinated. You're going to have policies to ensure that no one is providing care prior to the first dose of their vaccine, which I'm going to talk about that in a little bit, because that's something we have questions on. You need processes for requesting exemptions, tracking and documenting your exemptions and the outcomes of those requests, ensuring that all medical requests meet the documentation requirements, because there are specific requirements that need to be met when documenting or making your case for a medical exemption. We also have some questions on medical exemptions, which I'll cover in a minute. You need a process for tracking the vaccination status of all staff, including those who are requesting or granted an exemption. You need a process for tracking your booster shots, even though booster shots are not required to be considered fully vaccinated for this rule. You are only required to complete your primary vaccination series, the single shot of the Johnson & Johnson, or the 2 doses of either Pfizer and Moderna, or a vaccine protocol that has been approved by the World Health Organization. And then you also have to have a process for documenting any delays in vaccination. So for example, if a person would contract COVID-19 and on, say, December 1st, and they're not vaccinated yet, and they can't, of course, get that first shot until they're off of transmission-based precautions. That's a temporary delay that could be an exception to the rule, but then, of course, they would need to be vaccinated as soon as they're off of transmission-based precautions. Another exception, that temporary delay that you need to be tracking, are for individuals who received monoclonal antibodies and convalescent plasma, because as you know, there's a 90-day delay there before they can become vaccinated. And so that's another exception, that they don't necessarily have to be vaccinated according to the compliance states because of those CDC recommendations, but you do have to have the process that's tracking that delay and what the plan is to make sure that they do complete the vaccination series. And then, of course, you have to have contingency plans for any individuals who are unvaccinated, including contingency plans for large numbers of unvaccinated staff in such as an emergency situation. And the example that CMS gave is that you have an emergency where you need to evacuate your organization. And so you have to bring in 10 or 15 volunteers who are unvaccinated or whose vaccination status is unknown. That is something that, of course, can't be avoided because it's an emergency situation and you need to evacuate residents as quickly as possible, but you need to have a plan in place that says how you're going to make sure that those individuals are still taking the safety precautions needed to limit transmission or to mitigate any risks. So that's everything for phase 1. Phase 2, which is again January 4th, you're required to have the second dose in a multi-dose series, but this excludes that, or can exclude, the 2-week wait period. So typically, in order to be considered fully vaccinated, it is your second dose plus 2 weeks, and then you're considered fully vaccinated. But CMS says for the purposes of this rule, for initial compliance only, so only for that January 4th date, they're waiving the 2-week requirement. So if you get vaccinated with your second dose on January 3rd, you are considered compliant. However, that individual then needs to continue to adhere to those additional precautions and the contingency plans that you've put in place for unvaccinated individuals until that 2-week period has passed and they are fully vaccinated according to the CDC definition. Next slide, please. So as I mentioned, we do have a lot of questions. First of all, in the rule, CMS has gotten a little funny with the language, right? Because they talk about the possibility for medical exemptions, and they say you might request a medical exemption for something like a disability, a medical contraindication, or a recognized medical condition. But then when they're talking in the body of the rule about those medical exemptions, they refer to the CDC guidance on medical contraindications. And as you all are aware, that CDC guidance really only points out 2 contraindications, which is a severe allergic reaction or an immediate allergic reaction to the vaccine, the actual COVID vaccine, or components of that vaccine. So that is one of the things that we are seeking clarification from CMS on, whether it has to be that CDC definition for medical contraindications, or if there might be other contraindications that could be allowable for granting a medical exemption. We're also asking about what types of additional precautions providers need to have in place, because in the rule, it recognizes that certain provider types, excluding nursing homes, don't have infection prevention measures. And so those provider types would have to then put specific infection control measures in place for unvaccinated individuals, such as, or individuals who are not fully vaccinated, such as those who haven't received the second shot, or those who have either requested an exemption and are pending the result, or have been granted an exemption. But they note that for places that do have infection control requirements, like nursing homes, that the nursing home would have to come up with some additional precautions. And so we're seeking clarification from CMS. Does that mean that in addition to the PPE that's already required, and in addition to the testing, routine testing of unvaccinated staff that is already required under a different CMS rule? We've also got a question into them about how to handle new hires. It's our understanding that anyone that is hired prior to December 5th has to meet that December 5th deadline, that they need to have at least their first dose or have requested an exemption. Anybody who is hired between December 5th and January 4th, how does that work out? Do they have, can you hire them after December 5th when they're unvaccinated and get the first shot, and then have a plan in place for them to get that second shot, which may or may not be by January 5th or January 4th, I'm sorry. And for anyone who's hired after January 4th, is the expectation that those individuals will be fully vaccinated with the 2-week wait period prior to beginning any work at all? And along those notes, when would the additional precautions and contingency plans have to go in place for those new hires, or for those who have only had one shot, or for those who are requesting or have been granted an exemption? Do those things have to go in place before phase 1 or phase 2, or are those additional precautions and contingency plans only for after phase 2? And then lastly, we have a question to CMS about how to handle your non-certified parts of your organization, for example, in a life plan community. The reason that this is becoming really confusing, I think, is the rule really clearly clearly lays out who this rule applies to, right? It's CMS settings. And for our membership, that's typically nursing homes, home health, hospice, ICF, IID, and PACE communities. But there's number one, the question about how to handle HCBS. And then, like, for example, adult day, or how to handle assisted living. But then there's also this question that in the rule, it very clearly states that individuals who have contact with other staff, even if they have no contact with residents, they would be subject to the vaccine mandate. And so when you have your life plan community, and you have staff in your nursing home, and you have staff in your assisted living, and maybe the assisted living staff are not in contact with nursing home residents, but they are in contact with nursing home staff, or maybe they have shared common areas, how is that going to play out, right? Because there's plenty of language in the rule that states that those individuals would need to be vaccinated, and yet they're not part of your certified nursing home setting. And so it's just a lot of things that we don't quite know yet. We do know that there is guidance forthcoming. We don't know when it's coming, but we do expect these questions to be answered in that guidance. And next slide, please. And so here's what we can do now. We can determine the vaccination status of those working in our organization. For nursing homes, you've probably been doing this, right? Because you're required to be reporting on vaccination status through NHSN. But for some of our other member settings that are not reporting on vaccination, you may not have been tracking this. So we want to make sure that we're determining the vaccination status of everybody in our organization. And that includes licensed practitioners, students, trainees, and volunteers, contractors that we work with, anyone who's providing services under arrangement or contract. You guys are pretty familiar with that definition by now. You want to be communicating with all of those individuals exactly what's in the rule. And that's going to be especially important for communicating with those contractors, the people who may not be in your organization on a daily basis, but who will be subject to this rule. You want to be educating, of course. You guys have been doing this, right? But continue educating staff on the importance of the vaccine, the components of the vaccine, any questions they may have, and offering opportunities for vaccination, whether that is an on-site vaccination clinic or helping them to access vaccination in the community. And then, of course, you want to get to work on the policies that we talked about, because remember, those are going to be due on December 5th with that phase 1 compliance. I think it's also a really good idea to make sure that staff are aware of the other rules at play. Corey's going to talk about the Osha rules, so it's going to be really important for them to understand those and how they play into this rule, but also how it affects other settings, because one of the concerns that we heard from a lot of people when this vaccine mandate was first introduced was people are going to be leaving the nursing home and going to settings where it's not regulated. And then when the announcement came that it was being expanded to other CMS certified settings, then the concern was people are going to leave healthcare altogether and they are going to seek employment in other industries and other fields where the vaccine is not mandated. So you want to make sure that they understand that actually the vaccine is mandated in certain other settings and in certain other fields. You also want to make sure that everyone understands what challenges are out there, which Corey's going to talk about the challenges to the Osha rule. We are aware of some challenges to the CMS rule, but also what we're hearing is that they're probably not going to be successful. And so we don't want staff leaning on that and expecting that the rule is not going to be final, or that the rule is not going to be implemented, right? It is final, it's an interim final rule, but we don't want people sitting around saying, oh, this rule is not going to pass, it's going to be, pulled back or whatever. And then they get up to the last minute and you're kind of stuck. And so just being sure that you're clearly communicating with everyone on that. And then lastly, making sure everyone understands that the CMS rule will supersede any state law, or if your city or county has some kind of local or jurisdictional law that prohibits a vaccine mandate, this CMS rule actually trumps that because of the supremacy clause in the US Constitution, which CMS has been careful to very clearly state in the rule. So you just want to make sure that staff understand that as well, and that they're not they're not making decisions on a lack of information, right? That everyone has all the information in front of them that they need in order to make the most informed decision, and hopefully it will be the best decision to help your organization move forward. Next slide, please. So I've included a few resources here. We have the text of the rule. CMS put out some frequently asked questions. It's a very long document. It's pretty helpful, but again, we do expect more information to be coming out in the guidance. There's also a link to the CDC contraindications there. There are two more things that I wasn't able to get linked on the slide. One of them is a article that Leading Age has put out that kind of summarizes the rule and talks about, where do we go from here, which I can put that link in the chat. And then just last night, we sent a letter to the administration raising some of our questions that we have and really expressing the need to get these specific questions into guidance, which I covered on today's slides, and asking for a meeting with the administrator so that we can really hash these out and make sure that our concerns are fully addressed. So I can take questions now, or I can take questions after Corey. Either way is fine.
Oh, Jody, thank you so much. Go ahead with the questions now, if that works for you. Thanks so much. And also the article that you mentioned and the letter that you mentioned will be in our newsletter tomorrow.
Perfect. Thank you.
Yeah. We have a question. Do these phases extend to the residents as well, or is it just the staff currently?
Yep. So this rule is only for staff. CMS can't regulate what residents are supposed to do. And I believe there's actually language in the rule that clarifies that residents still have the right to decline vaccination, or their representatives have rights. So the rule and the phases apply only to staff, but remember that staff includes anyone who is providing services to your residents or patients or clients on behalf of your organization.
Great. That's a great segue to the next question, Jody. What about people who may come on site to do annual sprinkler inspections, painters, plumbers, cable company workers, and other such trades? Do we have to assure that they are all vaccinated?
Yeah. It depends. There's some things that you want to be asking yourself about these different entities. CMS did cover some of it in the rule, and they provided some examples because they say that there are certain exceptions. The exceptions they describe are infrequent, ad hoc, non-healthcare services. So one example was the annual elevator inspection, or annual sprinkler inspection would probably fall under that as well. They also said that it may be that a person who is coming in to make a one-time emergency repair, or somebody who's making a delivery, those might be people who were an exception, but you really need to evaluate how infrequent is their visit, right? Is it that they really only come in once a year? You've had this one emergency that they're coming in for, or this one annual inspection that they need to be in the building? Or is it that they're in there once a month and it's always the same person, or it's always the same company that's coming in? You also want to take a look at the contact that they have. Are they in contact with residents? Are they in contact with your staff? Or are they in common areas where residents and staff may be? And actually, an example that they provided of this was, if you're having construction done in your building, you have your construction workers on site, they might be doing all of their work outside, and they might not have any contact with residents while they're working outside, but they're coming inside to use your bathroom, or they're coming inside to eat meals in the cafeteria. In that case, those people, CMS said, would need to be vaccinated. So it really is going to be something that you're going to have to spell out in your policy. But I think CMS's intent is that most people that are coming in your building, if not all people coming in your building, are going to be vaccinated.
Well, I think that addresses the next question that came in about movers. So they're coming in the
Yeah.
building, it would be applicable. Jody, there's a question about religious exemptions being allowed.
So they are allowed. CMS really didn't touch this with a 10-foot pole in the rule. They basically just said they're allowed. Make sure you're not discriminating. And here's some guidance from EEOC. But that's kind of all they said, right? You as an organization need to create your own policy. There are a few different resources that you can look at, and I think Corey actually covers those. But an interesting thing that I just learned last night with our call with CMS is, and this may explain why CMS kind of didn't go there, is because religious exemptions are actually under a different agency's authority than CMS. So that may be part of it, but CMS is really saying that religious exemptions can be granted for a sincerely held religious belief, observance, or practice, I think is the language that they use. But they should not be used as simply as a way of avoiding vaccination. So how you determine that, it is going to be tricky, but CMS is not offering a whole lot of guidance on that, unfortunately.
Thanks, Jody. A couple more questions coming in, and family members providing services such as paying bills, house chores, grocery shopping, etc., for a resident. What would be the case there?
Yeah, so I think what's really going to matter there, and how you're going to make your determination, is who that arrangement is with, right? Because if it's running errands for the resident, and the resident is the one who's made the arrangement with the family member, then it's like they're a visitor. And you can ask about vaccination status, but they wouldn't necessarily fall to be subject to that. However, if you have like a personal shopper, for example, in the nursing home where I used to work, we had an agreement with a family member who volunteered to do personal shopping for all of the residents. And she would come in once or twice a month, and she would get the money from the residents and the list of the things they needed, and she would go out and pick them up and then bring them back to the resident. In that case, she had an arrangement with us, the facility, to do that personal shopping, even though she was shopping for the residents. And so I think that would probably fall under the category that needed to be vaccinated.
And this comes up a lot about a requirement to make sure that the family members and visitors are vaccinated. Could you comment on that?
Yeah, so CMS can't require family members to be vaccinated, but they do not prohibit you from asking. The only thing is that you can't ban them from visiting based on vaccination status. And so you can work with families to understand the importance of vaccination and other visitors. You can even offer to help them access vaccination, whether it's going out into the community, or I don't know, maybe you set up a vaccine clinic in your own organization. We've heard of some doing that before, but CMS doesn't regulate family visitors, and you as the organization can't ban a visitor based on vaccination status. Of course, you are allowed to restrict a visitor who is not following the safety protocols, or is visibly ill, showing signs or symptoms, isn't off of transmission-based precautions, that sort of thing.
So just to reiterate, no requirement, but you can ask. And if they're not following the safety protocols, you can ban.
Yeah, and that's consistent with the rules that were out prior to this vaccine rule.
Yeah. Well, no other questions are coming in, Jody. I hope you can stick around just in case they do. And we always appreciate your overview. I'm sorry, was there another question?
Thank you. I was just cracking up earlier when you asked about the construction workers, because I thought you were going with that with surveyors, because that's always everyone's question, which CMS has stated that they are they will be issuing guidance about vaccination for their federal surveyors and state survey agencies. So that is some good news.
Well, it's long overdue. Yeah, thank you. And by the way, I am Paula today because of these technical difficulties. So it's great being Paula for a day. Well, thank you, Jody. And I am going to hand it over to Corey now to talk about the OSHA Emergency Temporary Standard. Thanks for being here, Corey. Over to you.
There we go. I'm not muted anymore. My pleasure. Glad to be here, Dana. And as we all know, the OSHA Emergency Temporary Standard came out last Thursday, along with the CMS interim final rule. And so I'm going to kind of go over what it is, who has to comply with the OSHA rule, what are the requirements of the OSHA rule, kind of discuss briefly the legal standards or the legal challenges that are out there to the OSHA rule, and then what to do now if you're a provider that is subject to the OSHA rule, okay? And so what the OSHA rule, what is an emergency temporary standard? So think about this for a second as we're all immersed in the CMS world and dealing with those rules or state rules. A OSHA standard typically takes about 7 years to get enacted, okay? And so OSHA moves a little slower just because of the Occupational Safe and Healthy and Health Act based in the early 70s. So their standard setting process is a little different. It takes 7 years. An emergency temporary standard is an option that's available if OSHA determines that there is a grave danger and there is a necessity to come out with a emergency rule. And so we were first initiated with emergency temporary standard earlier this summer. That it was the one that dealt with healthcare. I call that one the OSHA healthcare ETS, and the one that was dropped last week is the OSHA vaccination and testing ETS. Keep in mind that June healthcare emergency temporary standard is still in place until December 20th. It does not expire until that time unless OSHA plans to extend it or do something different, but we've heard no indications at that point. So a lot of the healthcare providers in this space are dealing with that OSHA ETS from June, which is still in place. So keep that in mind. So with this new emergency temporary standard, what they did is they went and said, we need to have a vaccination or a vaccination and testing option for all businesses with 100 or more employees, okay? So this is for businesses outside of healthcare, and I'll get into some of the exceptions on who doesn't apply to with the OSHA rule here, but that was the general overview, was that we needed something to apply to all employers, whether it's retail, whether it's manufacturing, any employer that's out there. And so what they did is they came up with this emergency temporary standard. The deadlines are very similar to the CMS deadlines. You need to, it's in effect now, it's actually stayed because of the court challenge, but it's in effect as of the publication last week in the Federal Register. All requirements need to be done by December 5th. You need to have a plan in place. And then by January 4th, you need to have your testing system in place if you're going with the testing option for these employers. And to make this even more confusing and more exciting, they also made the emergency temporary standard a proposed rule. So unlike the emergency temporary standard this summer that expires after 6 months, they made this one a proposed rule. So there's 30 days to comment on whether this should be a standard moving forward and going through that process. So stay tuned. We'll be submitting comments by early December. So that's kind of the general overview. And they spent a lot of time in the emergency temporary standard explaining the grave danger and why it's necessary at this point. And so we'll spend some time commenting on that, as well as the technical requirements in December's comment deadline. We'll go on to the next slide. And so I think this is very important to figure out who this applies to and who it does not apply to, okay? So the applicability on the next slide there, please, is it applies to all employers with 100 or more employees, okay? That's just the general rule of who it applies to. They decided not to go to smaller employees right now because they thought employers with 100 or more employees had the administrative capacity to actually administer and deal with the costs and the hassle associated with the emergency temporary standard here. However, they have asked in their comments whether this should apply to smaller employers moving forward as well. Okay. Key though is who it does not apply to. It does not apply to those who fall under the federal contractor and subcontractor rule that came out a couple months ago. So that is the mandate that deals with federal contractors and those entities that have federal contracts with the federal government for services and or procurement and all of that, okay? It also does not apply to healthcare providers subject to that OSHA emergency standard that was issued in June, the healthcare standard. So if you remember, that was a very, very broad definition of healthcare, and it was specifically applied to nursing homes, it applied to assisted living, it applied to all these other settings where there was healthcare going on, okay? And so that excludes all of those folks. And as Jody mentioned, in the CMS rule, it specifically does not apply to assisted living, home and community-based services, adult day, all those providers kind of in the middle that do receive some Medicaid funds, but are not subject to any CMS conditions of participation, okay? So the CMS rule does not apply to them. This new OSHA rule does not apply to them. So they're kind of in the middle here where they don't have a vaccine mandate that applies to them. However, as I mentioned before, the OSHA June healthcare emergency temporary standard is set to expire in like 40 days here. So December 20th. So at that point, and what they've said in those frequently asked questions, I put the link there to the coronavirus webpage on OSHA, which has a ton of great resources, especially the frequently asked questions. So if you go into the frequently asked questions, it says that once that ETS expires, this new OSHA ETS may apply to some of those folks that were subject to the healthcare rule before. And so it's very, very confusing, and the assisted living are kind of in a limbo here. And in addition, I think one way to think about this too is assisted living not only is in this kind of gray area right now between these rules, but also if you're in a life plan community, how are you treating assisted living? Are you treating your whole campus as one, or are you trying to separate things out? I know when the OSHA healthcare ETS came out this summer, there was a lot of questions about that. You know, we know that nursing homes, it applies to assisted living, but can we separate out our independent living? And others who have initiated mandates before, they've done them in a whole campus. I think for a couple reasons. Operationally, it's much easier if you're addressing it as a whole campus. And then second, it's really hard to distinguish and tell your employees that, oh yeah, this is going to apply in one area where they need to get vaccinated, and these employees over here do not need to get vaccinated. That's a really tough thing to communicate with your employees, and is difficult from an employment law perspective as well, and morale perspective. So those are a couple of things to consider as well. And it does not apply to public employees in states without a state plan. OSHA, Virginia does have an OSHA state plan, and so they'll be following up, and so that exception is not going to apply to you. So who theoretically then is this going to apply to? It's probably going to apply to housing providers, okay? And those housing providers who have 100 or more employees, all right? So then the next key question is, how do we count employees? And if you go into section 2 of the frequently asked questions document that on the OSHA website, they go through the list of how to count, okay? They're looking at counting an employee-wide corporate firm-wide setting, okay? So let's say you have, under your umbrella of, as a housing provider, let's say you have 20 communities and they have 5 employees each. You would add those all together and you would have 100 employees as the employer, okay? So looking at the employer and on the company-wide approach. You're gonna count part-time folks, you're gonna count people who work off-site and work remotely to get to your 100. They're not gonna, the rule itself isn't gonna apply to them because they may work remotely and not go home, but they're gonna count towards your 100. You can count temporary or seasonal workers. You're not going to count independent contractors, volunteers, staffing agency personnel in those scenarios. And so they lay that out pretty nicely. So you can tell based on your organization, how you're structured, how to count those numbers and get to that 100 threshold, okay? And let's say you don't even make that 100 threshold. All right, so this rule will not apply to you. You can still move forward as an employer and initiate a vaccine mandate if you choose, okay? Because we've had other providers that issued a vaccine mandate early on, and so they're already in a really good spot to comply with, the CMS rule specifically, but you as a private employer can issue a mandate whether any of these rules apply to you or they don't apply to you. Now, there's employees that they aren't going to apply to. As I mentioned before, those who work from home, those who do not go to a workplace where there's other people. So let's say their workplace is just them, and they show up somewhere, they don't have to actually, aren't subject to the rule. And then those who work exclusively outdoors. There's very few people that's going to apply to, but it may apply to some people. I don't think really in our field at all. Let's go on to the next slide then. And so we've got the requirements of what we need to do here, okay? What you have to do is you have to implement a policy that is either sorry about that. My wife is printing something as I'm speaking. So not quite the dog interrupting, but it's another one that was just as loud. So here's the option. So if this applies to you, you've got 2 options. You can have a mandatory vaccine policy, or you can have a policy with a weekly testing option and allow those employees to get tested weekly, okay? Another thing you have to do is you have to determine your employee vaccination status. So you've got to get the information from your employees. They lay out in the rule how to do that. And then just follow those protocols. You have to support vaccination, and you have to provide up to 4 hours of paid time off to get each dose. And then you have to cover leave for those folks that are subject or suffering from side effects. Now, I would take a look at this because it's a little bit different than the OSHA medical removal benefits from the summer, and it's a little different from all the other provisions that you had before. So take a look at that if this applies to you and how you have to deal with those employee benefit leave provisions. The next one is testing and the cost of testing. So this was the big one, is who's going to have to pay for testing? And under this rule, I think we were surprised that the employer does not have to pay for testing. They can push the cost of testing onto the employee if they choose, with a big caveat. Those caveats being, if you have a union contract that requires the employer to pay, or if you've got a state law that's in place that requires the employer to pay for the cost of testing, then the employer will be on the hook. And so we'll go to the next slide then. There is some notice and removal provisions, real similar to what we've seen before, is if an employee is ill or gets a COVID diagnosis, they need to tell you, and then you need to remove them from the workplace. Face coverings, this is the other part. So if you let those folks who are unvaccinated do the weekly testing option, they have to wear a face covering in the workplace, all right? For us, kind of a no-brainer. We've been dealing with face coverings for a long time, but nonetheless, that is the requirement, which is new for some industries potentially. Then you've got some record keeping and reporting obligations to OSHA. And then finally, there's enforcement and penalties. The enforcement is they'll look at investigations and complaints, penalties up to $13,000 per instance of violation, or $136,000 if there's a willful violation and you're purposely ignoring it. Those are kind of the provisions. The rule itself isn't particularly long. The preamble is very, very long. And so I urge you to take, if you're looking at the document, skip to the end and look at the actual regulatory language. It's pretty straightforward in that sense. Let's go to the next slide and talk about the legal challenges. We've all heard that there was challenges filed. It was issued last Thursday. It was published in the Federal Register on Friday. Lawsuits came filing in on Friday. And the Fifth Circuit Court of Appeals, who has one of the lawsuits, issued a stay of implementing the OSHA rule pending a further review on the merits of the arguments, okay? And so now we're at this position where OSHA can't enforce it at this point until we get a decision from the Fifth Circuit Court of Appeals. They had all the briefs that were filed by the government and the plaintiffs as of close of business yesterday. And so I anticipate we'll hear a decision from the Fifth Circuit pretty quickly. Now, the Fifth Circuit, just so you know, covers the states of the federal district courts in Texas, Louisiana, and Mississippi. So that's the Fifth Circuit Court of Appeals. They're one of the more conservative courts of appeals in the United States. And so we'll await their decision. Now, there's also appeals pending in the 6th, the 8th, and 11th, and I think maybe even the 7th Circuit. So we may have these other circuits that jump in and concur with what the Fifth Circuit Court of Appeals said or reach a different decision. And then ultimately, one or two things are going to happen. It will go up to the Supreme Court, or they may actually consolidate all of these Circuit Court of Appeals and then pick a random Court of Appeals to actually decide the case before it then goes to the Supreme Court. So we'll wait and kind of follow those and see what happens right now. So what do you do now, since we're kind of in this space where we know the deadlines are approaching in December and January? We also know that there's a stay, but that stay could be lifted anytime. And once that stay is lifted, everything goes back into effect immediately. So what I would do is I would first see if this applies to you. Make sure you spend the time to figure out if that counting to 100 gets you to that threshold, and then just review all of the requirements that are in place there, and just be prepared and ready to go if this actually moves forward and is going to be enacted and enforced. And so we'll keep you posted on what we hear. And also keep in mind, I think that's why it's important to prepare now, is that this may yo-yo back and forth. The Fifth Circuit may say it's, they don't have the authority. Another circuit court says, yes, this can move forward. So ultimately, whether the enforcement can go on while we're waiting for a final court decision, we just don't know. So I think it behooves you to prepare, see if you meet the threshold, and move forward as if you'll have to enforce this rule as soon as a final decision is made. And so the final slide that I have is a bunch of resources. Whether you like OSHA or not, they do a really good job with their resources page. And so I put in a lot of the resources from their website, and I'd be happy to answer questions now or offline if you've got unique scenarios to kind of figure out if this rule applies to you, and then how to comply with all the requirements. So I'll turn it back to you, Dana.
Thanks, Corey. That really appreciate great information. At this time, we don't have any questions in the chat, but I would encourage here in these last few minutes, if you have any questions, please let us know. I will take this opportunity just to revisit that update I gave at the beginning about the staffing requirement legislation that the Joint Commission on Healthcare is considering. I want to let you all know that any type of legislation that does move forward, we are advocating for a workforce component, that the plan includes some type of legislation plan to increase the pipeline of staffing. So we have raised that issue with the Joint Commission on Healthcare. They are also investigating ways to have enforcement and oversight. So if a bill were introduced regarding nursing homes having to comply with the CMS acuity-based staffing standard, for which you already do, the state would need to come up with a process for oversight and enforcement of that. So we, there's some things that they can do about monitoring nursing home compare, monitoring the information that is reported and so forth. But I just wanted to let you all know that those are some other issues that we're working with on that. This does seem to be the most person-centered care option for the state to pursue, because it is a staffing mandate that would be placed on a nursing home for what CMS is determining that nursing home needs to have based on the acuity level of the residents. So we really do think that is the most person-centered approach. So with the last 5 minutes, I wanted just to open it up. You can come off mute and ask any questions you might have about that, or any questions related to CMS or OSHA for Jody and Corey. Okay, well, hearing none, we will make sure that we have all this information for you in our newsletter tomorrow, all the links, a recording of the call, and this PowerPoint, and we'll be getting updates to you. And want to thank Leading Age National for being on today. Really appreciate their support and all the information that they've provided, and hope everybody has a great rest of your week. Thanks so much.